Pike, one of the labor and employment attorneys at Hegquist and Eck, and I want to explain how California workers have the power to say no to forced arbitration agreements at work.
I'm an employee and my employer wants me to sign an arbitration agreement. Do I have to?
Maybe not. In California, some workers may be allowed to say no to forced arbitration agreements as a condition of employment.
So how does this work?
Two recently enacted California statutes in the Labor Code and the Government Code protect an employee's right to not give up access to the courts as a condition of employment. Now, among the rights that would be protected by not giving up access to the courts is the right to not be forced into arbitration, which is a non-judicial forum for dispute resolution.
So then what happens if I say no and they don't hire me or I get fired?
Well, those same statutes contain anti-retaliation and anti-discrimination provisions that make it an unlawful employment practice for an employer to refuse to hire or to take action against an employee who refuses to sign an arbitration agreement as a condition of employment.
But what if I already signed an arbitration agreement? Can I get out of it?
Probably not. These laws protect the right to say no when you are presented with the forced arbitration agreement, but they don't work to invalidate arbitration agreements that have already been signed by current employees. This rule is going to be limited to claims under the California Labor Code and the California Fair Employment and Housing Act.
What are those?
Claims under the California Labor Code are usually claims for minimum wage violations, overtime violations, and other violations of core labor law. The Fair Employment and Housing Act protects employees from unlawful discrimination and harassment on the basis of the traditional protected categories such as sex, gender, race, national origin, etc. that you may have heard about in other contexts.
So then what do I do if I think my rights have been violated?
You should contact an experienced labor and employment attorney who can advise you on whether you might have a cause of action against the employer for unlawful discrimination or retaliation.
All right, so who do you recommend?
Well, you could follow the link in the description down below to consult with an experienced labor and employment attorney right here at Hegquist and Eck.
Thanks for watching. Comment, like, and subscribe for more videos.